The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated, everyone. Welcome to this special session of the Iowa Supreme Court at Creston High School. It's a pleasure for us to be in your community this evening, and thank you so much for spending a portion of your evening with us. We have one case that will be heard this evening. It is Rosaline Sanon, Anemi Sanon, and Paulette Pogue versus City of Pella. Mr. Duff, you may proceed with your argument.
Please the court, counsel. Good evening. My name is Tom Duff. I represent the plaintiff appellants in this case. The City of Pella pierced the veil of immunity in this case by their failure to follow basic pool safety rules. And in doing so, they knew that the failure to follow those rules was dangerous. And as a result, two teenage boys, Nemson Sanon and Gael Creston, tragically and we think unnecessarily, died at the bottom of their swimming pool. The city have rented the pool to the Fellowship of Christian Athletes during the evening for money, knowing that that evening that the lighting in the pool was not adequate, and knowing that the water in the pool was murky, such that you couldn't see the bottom of the pool. The lighting condition was one that was well known to the city. Kevin Voss, who was the person in charge of the pool, knew about the dangerousness of the inadequate lighting, and in fact testified in a prior proceeding that he would have concerns about letting his own children swim in the pool at night. We believe that the immunity exception the immunity defense does not apply here because of the criminal offense exception found within 6.7.4.
Counsel, why did the legislature enact an immunity provision? What was the goal of that protection?
Well, I think the city would tell you, and I don't necessarily disagree, that when they drafted 670.4 subsection 12, that it does set forth the requirement that pools be registered and inspected. And I think if the pool is registered and inspected, that does raise a level of immunity. However, as they went on to draft that statute, they also used the words unless there's conduct that is a criminal conduct or malice.
Was the statute intended to foster community recreational activities?
Yes, absolutely.
And would we undermine that purpose if we expanded the definition of criminal offense that gets around the immunity?
I don't think so, Your Honor, and here's why. The criminal offense exception, the two that we're proposing, certainly the manslaughter, the involuntary manslaughter claim, is a much higher burden of proof. We have to prove essentially recklessness, which is not just ordinary negligence. With regard to the regulation exception, where we say that if there is a violation of one of those safety regulations, that's a criminal offense. And the safety regulations are there for a reason. And we do want to promote swimming pools, but we want to promote safe swimming pools.
Why do you think the legislature included an exception to the immunity for criminal offenses?
I wish I knew the exact answer to that, but I think they decided that there had to be some level of culpability at which a city or municipality would have to be held liable. And I believe that they probably felt that the criminal offense was a high enough level that it would get beyond ordinary negligence, which I think we're beyond in this case.
Now, the Court of Appeals decided this issue dealing with the statute adversely to you, and although I think it's an unpublished opinion, why were they wrong?
It is an unpublished opinion. We think they're, I hate to say that, I don't like to say the Court of Appeals is wrong, but I think what happened was one of the arguments that was not presented to them, that was not in front of the Court of Appeals, that is in front of this court, is the penalty statute that's found within the regulations at 641.15.8, which specifically talks about a provision of this chapter, meaning the administrative code. Anyone that violates one of these provisions is guilty of a simple misdemeanor.
Boy, I have some real questions about that, though. Your theory on this administrative code provision is that an agency of government, not the legislative branch, but an agency of government through rulemaking can impose criminal liability. That strikes me as doubtful.
Well, Your Honor, I would point the court to 135I, which is the enabling statute, where the legislature specifically said that the department could adopt rules in accordance with department being the Department of Health, and that it was for enforcement of the chapter.
Oh, sure, but of course they can adopt rules, and of course they can adopt rules for the enforcement of the chapter. That happens all the time. But ordinarily, that's civil enforcement. You can have a system of fines, you can have injunctions, cease and desist orders maybe. But a criminal sanction is an extraordinary sanction. It means you're exposed to imprisonment, substantial fine, and a stigma attached to it. Can an agency of government expand the scope of criminal liability simply through the rulemaking process?
Well, I believe they can, Your Honor. And the other thing I would point to is the umbrella statute, 13538, specifically says that talks about rules of the department being simple misdemeanors.
Well, I think that's an interesting statute, and I'd like to go right to the language. Frankly, I think you've got two statutory provisions that turns on the words actually used by the legislature. 135.38, and I'm just reading from it, any person who knowingly violates any provision of this chapter or the rules of the department, and you're hanging your hat, I think, on rules of the department.
Correct.
But the previous language talks about any violation of this chapter. The Court of Appeals suggested that that means 135, not 135I, which deals with swimming pools. You understand my question, I think?
Right. Well, and we think that the Larson court sort of read that of the rules of the department out of the statute. And I think if you look at what could happen if there can be some real absurdities or inconsistencies if you apply the statute the way the Court of Appeals suggested. There's a provision in one of the follow-up subchapters, 135H, dealing with psychiatric hospitals for children, that uses the same sort of language of this chapter. There's an enabling statute, and then the agency, which in that case was the Department of Inspections and Appeals, made regulations dealing with, for example, restraint of children. So if that language limits it to, for example, in that case, to just that chapter, then that would mean that there would be no criminal liability for unlawful restraint of a child. But then if you go to 135, the entirety of 135, which is the statute would start, which made the Department of Health, there's all sorts of penalty provisions. For example, one for pay toilets, where if you have a toilet in a public place that you charge money for, that's a simple misdemeanor. So you have this very odd situation where that's a misdemeanor, but something dealing with the child in a psychiatric hospital is not.
In chasing down the legislative history of these sections, I know that section 135.38 was enacted in 1897 in various forms, and it changed over the years. Chapter 135I was not enacted until I think the 70s, if I'm what does that do to your argument? Because 135 was in place with the language, this chapter or administrative rule, and 135, when it was enacted, only said this chapter. It did not say administrative rule. I mean, how does that help or hurt you? Or does it do anything?
Well, we think that the 135-38 is a catch-all provision for violations of rules. So I don't think it matters that this, when the legislature passed, and I think it was actually 1989, when they passed 135I, which is basically it's an enabling statute. It contains what you would typically see in an enabling statute, definitions, what the agency can do, and then it does set up a scheme for registration and inspections of pools.
Yeah, but before 1989, if that's the right date, you're probably right. The counties were responsible for the safety and regulations of pools, and in 1989, the state took over. I mean, and they did not, and they passed their statute which said what it said, but they did not include rules of this section. And does that cause a problem, or does that not cause a problem?
I don't think it does. I don't think it does, Your Honor. I mean, I think it's a catch-all provision to make sure that that when there is a rule violation, that's what they. Because as you point out, when that statute was passed, they had to have known that there was going to be subsequent General Assemblies that were going to pass other acts, which they obviously did. There's 135A through K, goes into 136, and they wanted to ensure, I think the reading is the proper reading is they wanted to ensure that no matter what, that the ruling, that a rule violation would always result in civil discipline.
Let me, go ahead. One more follow-up. Did you find anything in the legislative history of these statutes that would indicate 135-38 applies to other chapters other than 135?
No, what I found in the legislative history was that 135I was passed in 1989 or so, and that at the time that was passed, part of that bill, which was it's House file something or other, but when that bill was passed, it also included our criminal immunity exception, 670.4 was part of that bill.
I'm talking about the legislative history of 135, 38. Did you do any research into that?
I can't answer that question.
Let me try and follow up, because I'm on the area where Justice Wiggins has been driving. So as I read the statute too, the way this started out, this 135-38, this key provision started out, at the time it was enacted the first time, like over 100 years ago, there was one chapter relating to the Department of Public Health, right? And so it said, any person who violates any provision of this chapter or of the rules of the department, so it only would extend to that one chapter, even though it said rules of the department. Then we have in 1989 this 135I gets adopted, and that just says basically that violations of certain statutory violations are misdemeanors. It doesn't say anything about rules. So doesn't that 135I kind of supplant anything that's in 135-38 on the subject of swimming pools?
I don't think so, Your Honor, just because the 135I really only deals with, it sets up it's the enabling statute, and it sets up a scheme for inspection and regulations of the pools, and that's really all it does. And I think otherwise, if you read that, I just don't think you can read that section out regardless of, because they had to have known that more sections were going to be created, even if it was 100 years ago.
Your time is running out, but let me explore another theory of your case, and that's your due process claim. And briefly, the law you set out, I think, accurately suggests that where government acts with deliberate indifference, there might be a due process violation.
Correct.
But make the case on the facts here for deliberate indifference. May well be that a regulation in the administrative code was violated. It may well be, in retrospect, that mistakes were made. But clearly, deliberate indifference is a very high standard. And give me your best argument as to why you think the facts of this case cross that high threshold.
Certainly. And I would point out, deliberate, at least of the shocking the conscience standards, that's the lowest one. It's a reckless standard. But the facts that are essentially...
Oh, I think deliberate indifference is more than reckless.
But reckless or gross negligence. But the facts that are undisputed in the record, we think, that show deliberate indifference is that they failed to properly have trained, failed to have lifeguards, an adequate number of lifeguards. They had the underwater lights function, but they were not on. They failed to have adequate overhead lighting, even though they knew that without the submersible lighting, that the overhead lighting was not sufficient. They had an expert that told them that 16 months before these boys died, that your overhead lighting is not within the code, but they didn't do anything about it. And they allowed these children and 175 other children to enter the pool at night when you couldn't see the bottom of the pool. And
It
that's
sounds
really
like a
dangerous.
strong case for negligence, but Judge Jarvie in your federal action and Judge Hanson in the district court in this case both ruled that those facts didn't rise to the level of shocking the conscience or deliberate indifference. So why were they wrong?
Well, Your Honor, the standard that the cases set out, the Sanford case, some of the other cases from the Eighth Circuit, talk about conduct, action that the county or the city takes. And we think those are all affirmative acts. And I would point out Judge Jarvie, for example, he relied on the, I'm going way over my time. He relied on I think it's the Claiborne case, it's the swinging bridge case, which we think is distinguishable because these boys, they were not members of the public. They were invited to this pool. They were part of a group that was not open to the public. The swinging bridge case involved, the bridge rusted, so it was sort of a thing of nature, which this case is not. These are all man-made issues. So, thank you, Your Honor.
Thank you, Mr. Duff. And Mr. Palmer.
May it please the court. My name is Jason Palmer, along with Tom Bass. I'm here on behalf of the city of Pella. The first place that I would like to start is with some brief facts about the case. And one is about the lighting. I think in our briefs, you will notice that pursuant to the Iowa Administrative Code, there was no regulation that demanded that we needed underwater lights. And as related to the overhead lights, pursuant to 15.4 of the Iowa Administrative Code, there are two sections as it relates to lighting. One dealing with construction of lighting, and one dealing with the operation. It's very clear as it related to the operation of the lights. The only rule was that you saw the bottom of the drain with the lights on. And there was no allegation in this case, when the water clarity was proper, that you could not see the bottom of the pool.
Well, the water clarity wasn't there the night these boys died, was it? I mean, at least that's the allegation. I mean, there's some evidence in the summary judgment record that would suggest the water was not clear enough on that night to see the drain. Am I right?
That is correct. Since we filed our motion for summary judgment at the same time we filed our answer, for purposes of the summary judgment record, we did admit that fact.
And didn't the supervisor of the pool say he would not allow his children to swim at night?
That testimony did occur in the previous lawsuit.
Well, in the previous lawsuit, that's a powerful admission.
True, and certainly that's one man's opinion on how...
The man who's directly responsible for the pool, right?
Agreed. But I think as it relates to the deliberate indifference cause of action, you have to look at the underlying facts and the rules.
Oh, I agree with that. And here are the underlying facts, and correct me if I'm wrong. You knew the lighting was inadequate for 16 months prior to these boys drowning. You hired experts, high-priced experts, to testify in a civil lawsuit that the lighting was inadequate. These experts testified 2 days before these kids drowned, and they testified that the lighting was inadequate. So you are suing to recover money for inadequate lighting, and at the same time you're renting out a pool to collect money when your supervisor says he wouldn't let the children, his children, swim in the pool because of inadequate lighting. Now, could a reasonable jury conclude that's deliberate indifference?
I would disagree with the recitation that you provided, Justice Apple, and this is why. The previous lawsuit was based upon wiring of the underwater lights, and they felt there was a safety concern to use the underwater lights as it was constructed. Once again, it's important to look at Iowa Administrative Code 15.4, subpart 4M2, which deals with the standard for light.
But the underwater lights may have supplemented the outside lights to see the bottom or help see it. But at that time and place, there's a genuine issue of material fact that without those interior lights working, which may or may not be a violation, you could not see the drain of the pool.
I don't believe that's true, Justice Wiggins. The overhead lights, there's no allegation here that with water clarity that is proper, that you could not see the bottom of the pool with the overhead lights.
But there was no clarity that night, and you can't just erase that fact.
Agreed. There was not. But there was also not an allegation that with the underwater lights that you would be able to see the bottom of the pool. So in terms of the law and what the Iowa Administrative Code said, there was no requirement that you have underwater lights.
Why did your experts say you needed, assuming there was no underwater lights, your experts said you needed 4 additional sets of lights?
I don't
have that correct or not?
I believe that's what the experts did say. I did not represent the city of Pella in that lawsuit. Certainly differences of opinion exist as to what the Iowa Administrative Code states in terms of what is needed for lighting.
Well,
since there are provisions dealing with construction and operation, that could have been the difference. But at the end of the day, the only requirement for lighting is that you see the bottom of the drain.
Let me turn to the other issue, the legal issue about the statute. And I had a chance to go back and trace this thing back to 1873. And the statute was originally enacted in 1873, and when it was originally enacted, it dealt with a criminal penalty because counties were inspecting the swimming pool. There was no Department of Health. After the Department of Health came into being, it changed to the present statute, basically the language of the present statute. But in 1939, and this is what's interesting to me, they say any person who knowingly violates the provision of this chapter or of the rules of the department or any lawful order, written or oral, of the department or authorized agent shall be guilty of a misdemeanor. And that's the way the statute reads today, basically. But they had this extra sentence in 1939. And it said, if said rules relate to the practice of cosmetology or barbering, which is also under the Department of Health, said misdemeanor shall be punished by a fine not to exceed $100 or by imprisonment not to exceed 30 days, which seems to indicate to me that the legislature, when it said this rule, it said this chapter or rules was referring to rules of other sections because they're incorporating a different penalty for violating the cosmetology and for violating the barbershop. And then it's interesting, that sentence came out in 1976. It stayed there till 76. And it didn't come out because they amended 135. It came out when we did our new criminal code and we had uniform penalties for misdemeanors. And they wanted to make all misdemeanors with the same penalty. So tell me why, with this legislative history, we can't find that the legislature not only referred to rules of Chapter 135, but any rules the Department of Health might have promulgated, whether it be cosmetology, barber shops, swimming pools, anything else they may have done when you go through the list. Tell me why my logic is wrong.
Well, I think, first off, you don't even get to 135.38 because 641.15.8 of the Iowa Administrative Code, and that's what we're talking about, whether these administrative provisions are simple misdemeanors, states that these are simple misdemeanors pursuant to the authority of 135I.5. They don't say pursuant to 135.38. It says pursuant to 135I.5. And what does 135I.5 state? It says nothing about criminalizing the administrative rules. And we know through other statutes that are cited in both of our briefs that the General Assembly knows how to say that rules of the department or rules adopted in this chapter are criminal. But 135I.5 doesn't say.
Let me answer a question about that, Mr. Palmer. I mean, you don't dispute that if you go through 641-15.4, there are some rules that at least there's a fact issue that you're fine violating, right?
Correct.
Okay, all right.
As the record stands.
And there are rules that, according to that section of the Administrative Code, have criminal penalties, right? According to that section, right?
According to 15.8, but I don't believe that they're constitutional because they weren't mandated by the General Assembly.
Well, that's where I'm driving. When it says in 670.4 that there's an immunity except when there's a criminal violation by the city, your position seems to be you can go kind of past what is on its face a criminal violation and argue that the criminal statute is unconstitutional. Is that really what was intended when the legislature drafted 670.4? I mean, can you raise a preemption defense? Can you argue the statute's void for vagueness? Are we going to litigate a constitutional case inside a criminal case? You see what I'm getting at?
I think. As it relates to 674.112, which is now L, it does have the exception unless an act by an employee or officer constitutes a criminal offense. And we made the position at the district court, and that's subject to our cross appeal, that has to mean that there has to be a prior criminal charge and a conviction or plea in order for an exception to the very broad immunity that's been stated in Baker and Adams and Dang to be pierced. Because
do you have any case that says that?
I don't. I believe this is a matter of first impression. What we have are the definitions of constitute. We have the definitions of criminal offense, and we also have the rule statutory interpretation that you look at the practical results of a certain construction of a statute.
Let's assume that, for purposes of your argument, that you're right, that the administrative rule cannot criminalize the statute. It cannot criminalize the rules, okay? Why doesn't 135.38 criminalize that rule when you look at the legislative history that it was criminalizing rules in other sections by the Department of Health? The legislature knew it did because they had different penalties for different sections. And how do you get around that argument?
Well, I think first that the Larson court got it right. They were spot on. The one issue that I disagree with Larson and with the plaintiffs here is this notion that it's an umbrella statute. I'm not aware of any Iowa case that defines what an umbrella statute is. And what is it an umbrella statute of?
But the Larson case is not the law of the state of Iowa. It's an unpublished opinion.
Agreed.
And I don't see anywhere in the Larson case anybody talking about the legislative history of the statute from beginning to end. They just did a generalized thing. It's an umbrella statute. This modifies rules. It's only the rules in this chapter, which I find no support for. But, you know, let's forget the Larson case. Tell me without the Larson case, because this is your case of first impression on this statute, why we can't find, based on this legislative history, that when they said rules of the department, they did not mean rules of the department, not under 135, but any other rule the department may make for any other board or any other swimming pool, say.
Well, because 135-38 also states that a violation of this chapter is a simple misdemeanor. And to suggest that it's very clear that it's only it's a simple misdemeanor or violation of 135, but then to expound that and to include all other rules of the Department of Public Health that involve other chapters under the Iowa Code is inconsistent. Also,
let me try to record. Why didn't they, in Chapter 135I, they only said violations of this chapter is simple misdemeanor.
Yeah.
Why do you think they left out violation of this chapter or rules under this chapter?
Because the General Assembly chose and did not want to criminalize the rules under Chapter 15 of the Iowa Administrative Code. It's very clear.
Isn't it just as likely, though, that they knew 135.38 caught those? And you don't have to include it in 135I because 135.38 would catch those rules, which they seem by the legislative history to catch the rules in the other chapters.
If that is the case, I would suggest looking at 138.19 and 139A.25. Those are chapters of the Iowa Code that are under the Department of Public Health, but they also have penalty provisions. And especially 139A.25, that penalty provision is almost identical to the one in 135.38. So why would the General Assembly have a penalty provision in another code chapter that's under the Iowa Department of Public Health, a penalty provision that criminalizes the rules of the department when it's already in 135.38? Well, they did it because they know that 135.38 is not some sort of an umbrella statute, that penalty provision covers all chapters dealing with the Department of Health. That is why. And that's why the Larson Court got it right.
Well, the Larson Court got it wrong, and the reason for that is the two provisions that it relies on in 136B and 136C escalated the crimes and made it a serious misdemeanor. Of course, if the general rule is that violation of a rule is a simple misdemeanor, and then in a later chapter you want to escalate the crime, you have to do so specifically. But when you look at 135 and 135A, B, C, D, E, F, G, there is no provision under any of the chapters that restates that a violation of the rule is a simple misdemeanor. I don't think.
First of all, once again, going back to what is an umbrella statute of? 135A through 135M or L, many of those chapters do not deal with the Department of Public Health. They deal with the Department of Inspections and Appeals.
That's not a rule. It's not a rule of the department then.
But that may be a reason why those don't have a penalty provision dealing with a violation of that chapter. Number two, the issue isn't whether they increase the violation or they decrease it. The point is that they have their own penalty provision. And if they have their own penalty provision, the specific controls over the general. And it makes it redundant within the statutory construction. Just like 135I.5 has their own penalty provision. And if the General Assembly wanted to criminalize the rules of 135I.5, they would have said so like they did in 135.38, like they did in 138.19 and 139A.25. But they did not.
Well, let me try a theory on you. On 135.38. It says any person who knowingly violates any provision of this chapter is a serious misdemeanor. And obviously, that applies only to Chapter 135. The legislature has made a judgment that for each chapter, for violation of statutory provisions, it's going to have an individual penalty. And indeed, that follows. If you look at the next chapters, they provide it. But then they have an across-the-board rule for violation of rules. They're going to be simple misdemeanors, period, unless we express otherwise. So it's kind of a bifurcated approach. The language of the statute, looking at it, just 48 words or however many words, seems to support that interpretation, does it not?
I would suggest this, that under 135, there are over 40 chapters in the Iowa Administrative Code dealing with Chapter 135. It is not simply just one chapter, and that makes the reading of rules of the department sensible. Number two, I think that if you agree with the notion that Chapter 15 of the Iowa Administrative Code is indeed criminal, then look at 15.8. And they say it's criminal pursuant to 135I.5, not 135.38. That's reason number two, that I don't believe that position is correct. Number three, once again, look at 138.19 and 139A.25. Those are chapters that are under the Department of Public Health. They have penalty provisions, and they speak to the department rules being criminal. And if 135.38 controlled, there'd be absolutely no need to set that language out. For those reasons, we would ask that our motion for summary judgment be affirmed in all respects except the issue as it relates to a criminal offense. Thank you.
Thank you as well, Mr. Palmer. Duff, you may present your rebuttal argument.
I first wanted to follow up on Justice Waterman's question about the deliberate indifference, and I would ask the court to take a look at plaintiff's responses to defendant's statement of undisputed material fact that's found in pages 149 and 151 of the appendix. The city, I think, took the position that they could essentially admit all the allegations in my petition because it didn't matter because of the immunity provision. So if you look at those provisions, at those admissions, I think that goes a long ways towards proving our case of deliberate indifference. I also wanted to follow up on Justice Apple's question about can agencies make criminal rules? There is, and I found at least one in the food safety section, section 159, Department of Agriculture. It contains a similar language to 135I. It says violations of this chapter person shall be guilty of a simple misdemeanor. It has the enabling language. And then the Department of Agriculture promulgated rules and so forth on egg handling. And in those rules, it says violating one of these rules is a simple misdemeanor. So this is a fairly uncommon.
The difference there, I'm sorry to interrupt you, but the difference there is the legislature itself has declared violation of these rules as a misdemeanor. And I think the authority for that is clear. But it's a different kettle of fish for the agency to decide, well, let's promulgate some rules today. And we are going to declare that they're enforceable as criminal sanctions and that a violator can be deprived of liberty. That's a different proposition, is it not? You see the distinction I'm making? I mean, the legislature can authorize, the legislature can expressly say that violation of rules is a criminal offense. I have no problem with that. But an agency can't on its own, without express legislative authority, I don't think, decide to expand the scope of criminal liability.
Well, and in this case, I guess I would argue that the agency didn't necessarily do that. I mean, it's still a simple misdemeanor, but they were given specific authority in 135I to make rules and regulations to enforce the chapter.
Well, but enforce could be civil. I mean, normally enforcement to me means injunctive action, cease and desist, civil money penalties maybe, but not necessarily criminal sanctions.
Well, and it could be that the legislature, when they enacted 135I, was certainly was aware of the criminal exception that we're talking about in this case.
But the agency is nothing more than an arm of the executive branch. And under our system, the executive branch cannot pass criminal law. I mean, I learned that in 7th grade, I think. I mean, how do you get around that? And I think that's what Justice Apple, and in plain language, how do you get around the fact that the executive branch cannot make criminal laws because we don't have a dictatorship here?
Well, I'm not sure I guess I would disagree with the characterization that they're making criminal laws. They're only saying that violating one of our rules can be a simple misdemeanor. And I think under the Wallace case, which is one of the cases that the defendant cited, that they have the burden of proving that was not a rational the agency's interpretation to make that kind of rule was not rational. And we think that based on the language that's in particularly 13538 and 135I, that is certainly irrational.
Mr. Duff, could I ask you a question? In terms of your argument that Larson is wrong, and you probably know I was on the Larson panel, so I know, but I could have been wrong, obviously. One of the arguments you make is that 13538 covers rules outside of Chapter 135. And when I read Mr. Palmer's brief, he came back and said, well, wait a minute, look at 137D3. And 137D3 is a statute that says if there's a violation of a Department of Health rule relating to home food establishments, that's a simple misdemeanor. Now, Mr. Palmer pointed out, well, if that statute makes no sense if 13538 is a catch-all. And I didn't see in your reply brief any answer to that argument. Do you have one?
Well, I mean, my answer is still the same, that it's a catch-all, and the follow-up chapters, including those that came along, I mean, some of them elevate the penalty, some of them are serious, some are simple, some of them have no penalty at all. So I don't think that defeats the point that that it's a catch-all provision meant to pick up a rule violation. So I see him out of time. Thank you.
Can I ask you a quick question? Do you agree that we're just dealing with the concept of the general authority of the administrative agency to enact these regulations? Or is there some specific authority somewhere in the statute?
The only authority that I know of would be 135I of Chapter 17A. So I would ask that the court reverse all of the findings of the district court other than their finding that the criminal conduct here constituted the crime of involuntary manslaughter. Thank you.
Thank you as well, Mr. Duff. The case is now been submitted. Before adjourning court, let me just make a few brief remarks. In our system of shared decision-making in our government, it's very important for the public to be informed and to understand how that shared decision-making goes on among our three branches of government. Those words are not mine, but they were the words of Thomas Jefferson. And more to the point, it is most important for justice to be achieved, to be seen. Those two were not my words, but words borrowed from Oliver Wendell Holmes. I think tonight, the aspirations that those two men expressed have been captured by your attendance this evening, and we all commend you for taking your evening and spending it with us to sit and observe the court proceedings that go on every time we hear a case from across this state. I don't know if you know it, but Iowa has a very, very rich legal history that's captured in thousands of cases that are on our books that have affected our lives for almost 2 centuries and continue to do that today. And in every one of those cases, this is the process that was essentially achieved. It's thoughtful, it's contemplative, and justice is sought to be achieved. And this case will now be a part of that history. It generally takes us anywhere from a couple months to longer to actually get the written decision out. But just like the United States Supreme Court, follow, we have a term system, and we will complete our term at the end of June. And this case will be decided and filed and made a part of our law prior to the end of June. If you're interested in following along to the end result, you can go on our website, iowacourts.gov, and there'll be announcements on when the decision will be filed. We will join you for a reception immediately following this court proceeding. We'll just go in the back, take off our robes, and we'll come out and join you just outside the auditorium. Thank you so much again for your interest and for spending your evening with us. With that, the bailiff may adjourn court.